Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine you've got this brilliant idea, maybe for some financial tech, uses algorithms, seems totally new. First thing you think is, okay, I gotta patent this. But then you hit this wall, especially now in the digital age. Is your computer-based idea actually patentable, or is it just, well, an idea? That line gets really fuzzy. So today we're doing a deep dive into a case that basically redrew that line. The U.S. Supreme Court case, Alice Corporation v. CLS Bank. Yeah, this one's huge. We're going to unpack it, figure out what it means, and pull out the key things you need to know about what flies and what doesn't when you're trying to patent computer-implemented ideas. You've brought the key source material, the court opinion itself, so let's get into it. All right, let's kick things off. Set the scene for us. Who are the players? What court are we talking about? When did this all happen?
Okay, so this is a big one, went all the way to the top. U.S. Supreme Court. The case is Alice Corporation Pty, Ltd v. CLS Bank International et al. And the docket number is 13298. The judgment came down on June 19th, 2014, and it was unanimous, which is pretty significant in itself. Justice Thomas delivered the opinion for the court.
Unanimous, wow, okay. But there was a little wrinkle there, wasn't there? A concurrence.
That's right. Justice Sotomayor wrote a concurring opinion, and Justices Ginsburg and Breyer joined her on that. So they agreed with the outcome, but had a slightly different take, which we can get into.
Okay, interesting. So the parties, Alice Corporation, they held the patents, and on the other side, CLS Bank International and CLS Services Ltd. What was Alice's patent actually about?
Alice had these patents, several of them actually, for a method to deal with settlement risks.
Settlement risk. Okay, refresh my memory.
It's the risk in a financial deal that, one party follows through, maybe sends the money or the asset, but the other party doesn't. Fails to hold up their end. It's a big deal in finance.
Got it. So Alice had a fix for that.
Yeah, their idea was to use a computer system acting as a kind of neutral third party, an intermediary, to manage the whole exchange and make sure both sides could actually complete the deal. And they tried to cover all bases with their patents. They claimed, first, the method itself, the steps involved. Second, they claimed a computer system set up to run that method. And third, a computer-readable medium-like software, basically containing the code to perform the method.
So method, system, software, covering all angles.
Yeah.
How did this computerized intermediary actually work, though? What was it doing?
The core idea was using the computer to create these shadow records, shadow accounts, really. They weren't real money, just digital trackers mirroring the real accounts involved in the transaction. The computer would check these shadow accounts first. Only if both parties had enough in their shadow accounts to cover the deal would the system allow the transaction to proceed. Then at the end of the day, it tells the actual banks, okay, go ahead and make these specific transfers.
Ah, okay. So it's like a digital escrow, verifying everything before the real money moves. Seems clever. But CLS Bank wasn't impressed.
I don't have to think it was patentable, no. CLS Bank, which runs its own huge currency exchange network, basically went to court asking for a declaratory judgment.
Meaning they asked the court to just declare the patents invalid.
Exactly. They wanted the court to say Alice's claims were invalid or unenforceable, or maybe that CLS wasn't infringing them anyway. But their main argument, the one that stuck, was that these patents were aimed at an abstract idea.
That term again, abstract idea. And under U.S. Patent Law, Section 101, abstract ideas just aren't patentable subject matter, right?
Correct. Section 101 defines what can be patented processes, machines, manufactures, compositions of matter. But the courts have long said there's this implicit exception. You can't patent laws of nature or natural phenomena or these fundamental abstract ideas. Things like mathematical formulas or, as it turns out, certain methods of organizing human activity.
So CLS was saying Alice's whole risk mitigation thing was just a fundamental concept, a method of organizing finance, and sticking it on a computer didn't change that.
That was precisely their argument, and it had legs. The case had a bit of a journey, actually. An earlier Supreme Court case, Bilski v. Capos, back in 2010, had already dealt with patenting business methods and found risk hedging to be abstract.
Right, I remember Bilski. That kind of set the stage, didn't it?
It did. So after Bilski, the district court looked at Alice's patents and said, yep, these are directed to an abstract idea, essentially, using a neutral third party to reduce settlement risk. Patent ineligible.
And then went up to the Federal Circuit. That's the Special Appeals Court for patents, right?
Correct. And the Federal Circuit had a real struggle with this. They ended up rehearing the case en banc, meaning almost all the judges on the court participated, not just a typical three-judge panel. Even then, they were deeply divided, but ultimately a majority affirmed the district court. The claims were ineligible.
Wow, on bank review and still division. That just screams, Supreme Court, please clarify.
Exactly. It perfectly set the stage for the Supreme Court to step in and try to provide a clearer framework.
So the ultimate question for the Supremes was, when you take an abstract idea, like managing settlement risk, and you implement it using a computer, is that enough to make it patentable? Or is it still just an abstract idea? Okay, before we get the final verdict, let's dig into Alice's side. What was their argument for patentability? How did they defend their claims?
Alice pushed back hard. They argued first that their claims weren't abstract ideas in the way the court meant it. They tried to limit abstract ideas to only things like, fundamental truths, things that exist totally outside of human action, like Amos Bovary.
So like scientific principles or math, but not business methods.
Right. They argued their method wasn't like that. And crucially, they stressed that the computer played a substantial and meaningful role. It wasn't just incidental. They even pointed to specific hardware configurations needed.
So they were saying, hey, this isn't just an idea floating around. It's tied to a specific machine doing specific computer functions. The computer is the intermediary.
Exactly. They framed it as the computer itself being integral, performing these complex steps, creating shadow records, managing the process. It wasn't just, using a computer like a pencil and paper.
That sounds plausible on the surface, doesn't it? Especially today, where the software is often the innovation. So how did the Supreme Court respond to that? They still ruled against Alice unanimously.
They did. The court affirmed the Federal Circuit, holding that all of Alice's claims, the method, the system, the software, were drawn to a patent-ineligible abstract idea under Section 101.
And their reasoning. How did they cut through Alice's argument about the computer's role?
They leaned very heavily on the two-step framework from that Mayo case, Mayo Collaborative Services v. Prometheus. That case involved diagnostic methods, but the framework became key for software too.
Okay, break down the Mayo two-step for us in the context of Alice. Step 1.
Step 1. Are the claims directed to one of those patent-ineligible concepts, like an abstract idea? Here, the court said absolutely yes. The claims were clearly directed to the abstract idea of intermediated settlement. They compared it to risk hedging from the Bilski case, calling intermediated settlement a fundamental economic practice and a basic building block of commerce. They explicitly rejected Alice's narrow definition of abstract ideas. It's not just fundamental truths. It can also include these long-standing methods of organizing human activity, especially in economics.
Okay, so the core concept, abstract, that triggers step 2. What's that?
Step 2. If it is directed to an abstract idea, you then look for an inventive concept. Is there something more in the claim, something significantly more that transforms the abstract idea into a patent-eligible application of that idea?
And for Alice?
For Alice, the court said, nope, there wasn't enough. Merely requiring a generic computer implementation to perform the abstract idea didn't cut it.
So just saying do it on a computer isn't an inventive concept?
Essentially, no. The court was very clear. Simply stating the abstract idea and adding the words, apply it with a computer, is not enough. You need more. They looked at what the computer was actually doing in Alice's claims, creating the shadow accounts, getting data, adjusting balances, sending instructions, and they found these were all just well-understood, routine, conventional activities for any generic computer. There was nothing inventive about the computer functions themselves.
Ah, so the computer was just doing what computers normally do, but applied to this financial idea.
Exactly. The claims didn't, for instance, propose an improvement to how computers function, nor did they claim an improvement in some other technology or technical field.
And that's where the contrast with the Diamond v. Dyer case comes in, right? The rubber curing case.
Precisely. In Dyer, the court found the claims were patent eligible. Why? Because using a computer running a specific algorithm to constantly measure temperature and recalculate cure time improved the technical process of curing rubber itself. It wasn't just automating an abstract formula. It was a new and better way to do a physical technological process.
That's a really critical distinction. It's not that you use a computer, it's how you use it. and whether that houses itself an inventive technological improvement.
You've got it. The court in Alice worried that if they allowed patents like Alice's, patent eligibility would just become a game of clever wording, what they call the draftsman's art. You could patent any fundamental idea just by tacking on a computer.
And that would block off basic building blocks needed for future innovation, the preemption concern.
Exactly. Patent law is supposed to promote innovation, not stifle it, by letting people monopolize fundamental concepts.
Okay, so this decision really solidified that Mayo framework and relied heavily on Bilski and the older cases like Benson and Fluke about algorithms not being patentable just because they run on a computer.
Yes, it pulled together those threads, reaffirming that Section 101 has real teeth when it comes to abstract ideas implemented on generic computers. Dyer remains the example of doing it right, improving a specific technological process.
Now let's circle back quickly to that concurring opinion from Justice Sotomayor. What was her slightly different angle?
Right. Justice Sotomayor, joined by Ginsburg and Breyer, agreed with the outcome. Alice's claims were ineligible. But she wrote separately to emphasize her view, which she also expressed in Bilski, that claims directed solely to methods of doing business are generally not patentable processes under Section 101 at all.
So for her, it wasn't just that it was an abstract idea, it was also problematic simply because it was a business method.
Kind of. Her view is perhaps a bit more categorical about business methods. While the majority focused on the abstractness and lack of inventive concept, her concurrence suggests that maybe business methods as a category have a harder time qualifying under Section 101 unless they are integrated into something clearly technological in an inventive way. It adds nuance to the court's overall thinking on the topic.
Got it. So bringing this all together, what's the big impact? Why is Alice such a landmark case for anyone involved in tech, software, finance? Why should you care?
Oh, it's had a massive impact.
Yeah.
First, as we said, it really cemented that Mayo two-step framework. That's now the standard analysis for subject matter eligibility, especially for software and business methods. Courts use it constantly. Second, it definitely broadened the practical understanding of abstract idea. It's not just math. Fundamental economic practices, methods of organizing human activity, those are fair game for being called abstract if there's no inventive concept tied to them.
And the big one for developers and tech companies.
It significantly raised the bar. Post-Alice, it's much harder to get a patent for software or a business method if all you're doing is automating a known conventional process on a generic computer. You have to show something more.
That's something significantly more, the inventive concept.
Right. Does your invention improve the computer's functioning? Does it improve another technology? Does it solve a problem rooted in computer technology itself? If not, if it just uses the computer as a tool for an abstract process, you're likely facing an uphill battle under Alice. It really reinforced that concern about preemption preventing monopolies on the basic tools of innovation.
So the takeaway is pretty stark, isn't it? Your cool software idea, even if it's complex, isn't necessarily patentable just because it runs on a computer. It needs that genuine technological leap.
That's the core message. The focus shifted from the abstract idea itself to the application. Is the application itself inventive in a technical sense?
So there you have it. The Alice v. CLS Bank decision really is a cornerstone for understanding patents in the digital age. It tells us computers are amazing tools, but just applying an old or abstract idea to a computer, well, that's probably not enough to get you a patent. You need to push the technological boundaries themselves.
And that leaves us with a really interesting question, especially now with AI booming. What actually counts as a technological improvement today? When AI learns and mimics human processes, how do you draw the line between just automating an abstract concept and creating something genuinely new and technological under the Alice framework?
Definitely something to think about as you track innovation. Thanks for joining us for this deep dive into a truly critical case.